Hi girls. So during your offline classes, we had started with this chapter, customer and account holders, tab chapter 3. And with both the classes, I have done a few topics. So first one was we had seen who is a customer, and then we had seen different types of accounts in detail. Okay. So the next topic that I was supposed to be doing was the different types of customers. Okay, so this chapter is quite small, and hardly there were few topics, and the last topic to see in this chapter is the different types of customers. But the thing here is we need to go in detail with each of these different types of customers. So let's see the first type of the customer, who's called as the miner. Okay, so in this topic we are going to go in details with all the different types of customers and what is their nature of account or nature of contract with the banker, and what are those precautions that the banker should take with regards to these different types of customers. Okay, so we're going to see under different heads. Like I told you, firstly we will see a miner. All right, so we all know who a miner is. So basically any individual who is under the age of 18 will be considered as a minor. And the court of law also has certain discretions where if a guardian is appointed for a minor, then he will remain a minor until 21 years. Okay, so if there is no guardian as such appointed, and if he is under the natural guardians, that is the father and the mother, so once he is 18, he will become a major. But if the court of law or the natural guardians have appointed a guardian for the minor, then he will become a major only after 21 years of age. And this is as per the Majority Act 1875. Alright, now let's continue with this topic and see the nature of a minor's contract. Okay, so this minor's contract is something to do with the banker. Now I already told you that a banker and a customer shares relationship, that is you call it a contractual relationship, where this relationship will have its own rights and obligations in the contract. Now as far as a minor is concerned, and is the nature of his contract is concerned with regards to a banker, there are a lot of things that you need to know. So to start with the nature of a minor's contract, the first thing is, I told you that a minor is someone who is below the age of 18. And the minor can have natural guardians. Who are the natural guardians of the minor? It's none other than the father and the mother. Okay? And otherwise, the stepmother and the stepfather also will become the natural guardians. Alright. So, if a minor is married, like for example, if a minor girl is married, then obviously the minor girl's husband will be a natural guardian. Alright, so these are considered to be natural guardians for you. Now, any Hindu father for that matter can appoint a guardian. Alright, so this guardian will act only after the death of the father. And apart from that, the court of law also can appoint a guardian. So, when will the court of law appoint the guardian? When the court finds that the father is unfit to be the natural guardian. Alright, but otherwise, in the absence of the father, the mother would obviously become the natural guardian. Followed? Now, in the absence of mother as well, then the court of law will appoint a guardian. So, the Reserve Bank basically has advised the banks to permit the minors to open an account. Okay, and the father or the mother, okay, can help in the operation of the account. Now, apart from that, the minor is not actually capable of entering into any valid contract. According to Indian Contract Act, it clearly specifies that a minor is disqualified from entering into any legal contracts. But we must understand that a minor too is a human being, and he will also have his own basic needs and necessities for life, like food, clothing, shelter, and things like that. Okay, so for his necessities, the court of law allows the minors to enter into contract, right? So the Contract Act 1872 also states that a minor is capable of entering into a valid contract just for his necessities. All right, so like that here, holding a bank account, like maintaining some balance, saving some money also becomes a necessity for the minor. So he is allowed to open an account. All right, and he also can enter into contracts, and supposing he misrepresents himself telling that he's a major and enters into contract, then whatever, you know consequences he suffers, he will be definitely undergoing losses, and he will have to restore the losses that he has made another person to commit. All right, so now, talking about opening an account, I told you, yes, a minor can open an account, but provided he only is allowed to open a savings account and not a current account. So why not a current account is because a current account is which will allow you to overdraw, which will provide you with various different types of credit facilities. So basically, a minor is protected by the court of law. So any kind of liabilities tort that which will arise in a contract between a minor and another party, it is always that the minor is protected by the court of law. So the banker should try not providing loans, okay, any kind of overdraw facilities, that is overdraft facilities and things like that, because the banker will be in trouble in case the minor is not repaying back to the bank. All right. Now, once the minor reaches maturity, definitely the account which is already being, like whichever he had before, when he was a minor, that account has to be closed and a new account has to be opened. Okay. So, if a father dies, obviously the mother becomes the natural guardian. And if the mother also dies, then there should be a guardian appointed. Sometimes parents write up wills, isn't it? So after me, this particular property belongs to my child, or this particular person will take care of my child. So like that, in the absence of the mother or father, whoever is appointed as guardian by the mother or father can take over and take care of the minor. But supposing nobody is being appointed, then the court of law will appoint the guardian for the minor. Alright. Now, if a minor himself dies, then the guardian can obviously withdraw the balance account. Alright. So, if the guardian dies, then the balance can be paid to the minor, but only after he becomes a major. Now, why this minor major thing is always spoken of is because until unless a person is 18 years old, he will not have a stable state of mind. He will not have enough maturity to take decisions, to decide between what is right and wrong. So that is why the court of law always sticks to something called as majority. Okay, so if the guardian dies, there's a lot of money left with the banker. The banker will pay it only when the minor is becoming a major. All right. Now, apart from that, there is no any risk as such in opening an account. Okay, as long as overdrawing facility is not provided by the banker to the minor customer. Okay, and not only that, any kind of a guarantee that which is signed by a third party can also not be considered with regards to a minor. Supposing a minor takes a loan for which a third party signs, and if the minor defaults, that is, it doesn't pay the loan back, even then the third party who has signed the guarantee cannot be claimed any money by the bank. Not just that, if the minor is pledging any property, okay, for a loan, you know what, the banker cannot even exercise his right of lien over such kind of collaterals that which is pledged by the minor. Because as I told you already, the minor is always protected by the court of law, and he will not be responsible for any kind of liabilities or torts that which is arising out of a contract. Right? And not just that, a minor, okay, can definitely sign checks, he can sign bills of exchanges, okay, negotiable instruments, and those can be also honored but provided there is proper guidance of the guardian. Alright, and minors can draw, endorse, or negotiate the checks and bills but cannot be held liable for the same. They cannot be sued. So please remember that a minor cannot be sued in the court of law. A minor cannot be declared as insolvent. Okay, so the court of law always tries to protect him because he doesn't have enough maturity to make decisions. And can a minor be admitted in a partnership firm? Yes, definitely. He can be admitted in a partnership firm, but provided he is only going to be admitted for profits and not for liabilities. So these are all the nature of a minor's contract, girls. So now let's see the precautions that a banker needs to take when he is opening a minor's account. So first thing, as I told you, is a minor can only open a savings account and not a current account because it should not be allowed to be overdrawn. Credit facilities should not be given to a minor. So that has to be kept in the minds of a bank. Next thing, in the name of the minor, joint account can be opened. Yes, a minor along with. Yes. So whether a banker can open a joint account in the name of a minor, yes. The minor along with his guardian can open. Okay, but necessary precautions need to be taken. What are those precautions that has to be taken by the banker is first thing is he should make sure that the minor has attained the age of discretion. That is 12 years and above only he will be allowed to operate the account. Alright. And he should understand what is basically happening. He shouldn't be so innocent also that he doesn't know what is happening with his joint account. Right. Then the next thing is the minor should be able to read or write. Okay, English, Hindi, any regional language for that matter. And apart from that, the account should always show credit balance. Okay. And it should be overdrawn and things like that. Right. So the next important thing will be it's always advisable, okay, for a banker to open a minor's account in the name of a natural or legal guardian. Alright. And the guardian, of course, should make sure that, he is protecting the interest of the minor. And then the banker should also obtain some kind of specimen signatures of the guardian along with, yes, of course, the minor as well. Okay. So these are certain precautions that has to be taken, and in the event of the death of the minor, the money will be paid obviously to the guardian. Okay, but in the event of the death of the guardian, the money will be paid to the minor only after becoming major. Then a minor can be appointed as an agent, but a minor cannot have an agent. Alright, so he will also be able to sign all the bills of exchanges, checks, drafts, and things like that, provided it's under the able guidance of the guardian. So this is about the precautions that has to be taken by the banker when he is opening and operating the account of a minor. Yes, so that's about a minor, girls. So next we will see the joint account holders. So who are these joint account holders? So I told you that, yeah, you can also have a joint account. That is, an account will be in the name of more than one person. Alright, so 2, 3, 4, whatever. That is called as a joint account. Now, there are certain characteristics or nature of a joint account holder and the contract between him and the bank. So first thing is the bank should examine the request of the joint account application. Carefully you must examine. Okay, so usually these trusts, okay, NGOs or certain business organizations and all have joint accounts which can be operated by more than one person. So basically the requisition for the same should be properly verified by the banker, and then clear instructions should be obtained, okay, be it with regards to the depositors or with regards to the survivors, the person who are part of it, okay, the depositors jointly, and things like that. Everything in detail instruction should be received. Then the banker also must give clear instructions with regards to the withdrawal of the securities or the amount. And in case any one person becomes insolvent in the joint account, the account needs to be closed, because it is very clear that an insolvent, meaning a bankrupt person, cannot enter into any legal contracts. As a temporary disqualification, though, until a person becomes solvent, his all his contractual relationship should cease. All right. So even if one person becomes insolvent, then the banker should try taking into consideration the reason for insolvency and check with all the other joint account holders, and then decide about whether keeping the account open or not. So no payment should be made. Okay, it is not permitted to be made unless and until it is signed by all the people and is consented by all the joint account holders. Now, supposing a person before he becomes insolvent has given checks, so once he has become insolvent, those checks should be stopped. It should not be honored. But in a joint account, in case it is consented by the other members, okay, to make the payment of those checks which were signed, which were given by a person when before he was insolvent, then it is at the discretion of the joint account holders and at the bank. Okay, now on the death of a joint account holder, then there needs some kind of a concern into the account. That is if at all he's got some money left behind, like lien to be exercised, then his legal representatives, whoever is surviving, for him, the legal representatives, so they can claim all the money. Supposing there are no legal representatives, then the joint account holder, whoever is, like the other individual or the others who are part of the account, can claim the money. All right. So this also, okay, is something which needs to be brought to the concern of the banker, that there should always be if the joint account has a debit balance, okay, it should be brought to the notice of the deceased joint holders. All right. And if the banker has to pay the balances to the survivors, he should also get the requisition clearly signed by all the other joint account holders. All right. And apart from that, the joint account holders may also together nominate one person, okay, in case the account ceases because of the death of the joint account holders and whatever. See, for example, let us assume that if a husband and wife hold a joint account, and in case of death of both husband and wife, the money has to be handed over to the legal representatives, the children and things like this. So that is what is nomination. So like that, it is not necessarily always with a personal relationship, it could also be professional. So even in that case, certain nominations could be given so that the money in the event of the death of the joint account holders can be given to the person who is nominated. Let us now see the precautions that has to be taken by the banker. So first thing is, the application for the joint account must be signed by all the persons who are opening the account. That has to be checked by the banker. And then the banker should give clear instructions with regards to withdrawal of the money, the securities which is kept, like in safe custody, and with regards to insolvency and things like that. The banker should give clear instructions to the joint account holders, because later on the joint account holders shouldn't be saying that we were not aware of all such rules and regulations. Then the next thing with regards to joint account holder is no agent can be appointed, okay, by the, now for example, there are 3 members who are operating the account. Now one member cannot appoint an agent and ask that agent to operate his account. The joint account holders themselves should operate the account. All right. Now apart from that, it should also be clearly stated as to who may operate the account and what is his authority, who can sign the checks and who cannot sign the checks and things like that. All right. Apart from that, The authority to open can also be cancelled by the joint account holders, meaning to say that if one person becomes insolvent or one person has a problem, he doesn't want to continue on the joint account holding, the other people can give instructions and asked to put a stoppage on any kind of transactions relevant to that particular individuals who is leaving the joint account, contract, whatever. And then the full name of the account holder should be there in the documents, and uh, you know all the things should be given relevant to the identity of that particular individual's acknowledgements. Okay, the banker must also know when to allow the overdrawing of the account. Okay, so if at all there is a requisition, only then overdrawing of account should be allowed. So that's about the precautions to be taken with regards to the joint account holders. Okay. So next thing that we have to see is with regards to partnership firms. So we all know what a partnership firm is. This is a different type of customer. So a partnership firm is where individuals come together, contribute their capital, start up the business, share all the profits and the losses, and carry out their businesses. So now talk about the nature of a partnership firm's contract is there should be the minimum number of partners should be not less than two. That is obviously one person cannot be called then a partnership firm, isn't it? So at least two members. And it can exceed 10, 20, depends on the statutory limits given by the banker. Then apart from that, can a minor be admitted as a partner? Of course he can be admitted, but only for profits, not for liabilities. Then, at the time of opening the account, the application form should be signed by all the partners. So that has to be checked by the bank. And then, if supposing a partner is out of country, the other partners, of course, can operate the account, open the account, and operate the account. Then, specimen signatures of all the partners should be obtained, because one among the partner can present some instruments, instructions, and for which he'll be giving signatures, isn't it? So all the partners have the right to do so. So all the partner signatures should be taken into consideration. And then the authority for a partner to operate the account can also be cancelled, revoked by giving notice. The other partner should give notice to the banker telling this particular partner is right to operate the account is revoked, cancelled. So notification has to be given to the banker, and only then the banker will know and operate on the same. Then the partners can also stop the payments of the checks that which is signed by maybe an insolvent partner or a partner whose rights were revoked. And then a partner is also authorized to operate the account, and cannot delegate his authority to another person without the consent in writing by the other partners, meaning he cannot appoint some other agent or some other person as a partner by himself without actually, if you want to leave a partnership firm or you want to replace somebody in a partnership firm, you need the consent of all the other partners of the firm. Then a partner also has a power to borrow money on behalf of the firms. Okay, so because the partners are only representing the partnership firm, so they can take loans on behalf of the firm or in the name of the firm. And obviously, the liability of the partners in the partnership firm is unlimited. Whatever is the liability of the company will also be the liability of the partners, meaning the personal assets also will be considered to make good the losses that the banker has suffered. So all the debts of the firms are to be paid by the partners. And in case of dissolution of the firm, so the assets of the firm also will be taken into consideration to make good the losses that the firm has suffered. Okay, and the partnership changes also sometimes due to death, retirement, insolvency, and things like that. That has to be brought to the notice of the banker. Now, if a partner dies, the partnership, all the partners dies, or if one partner dies, sometimes the partnership firm will come to an end. Okay, there's no perpetual succession as such like that of a joint stock company and all that for a partnership firm. The partners dies, the partners leave, the firm will dissolve. So in such event also, the it should be properly brought to the notice of the banker. Okay. And no agreement, if at all there is no agreement in contrary. For example, if a partner dies and if there is no any will or wish that he has written, obviously who will get the money? It will be the other partners, or sometimes the legal heirs of the partner, whoever he has nominated. In case of dissolution of the partnership firm arising because of the death of the partner, the bank's accounts should be closed. Okay, no more operating the account after the partnership firm has dissolved. And insolvent partners' checks should not be paid. Okay, so only after confirming with the other partners, the insolvent partners, just like joint account holding, no? Here also, if one of the partner becomes insolvent, now his checks and all that can be honored only if other partners agree for the same. Alright, and apart from that, as soon as the partner is declared insolvent, the account should be closed and new account should be opened in his name after he becomes solvent. Now let's see the precautions that has to be taken by the banker with regards to the partnership firm. So first thing is, he must see that the partnership account must always be opened in the name of the firm and not in the name of an individual partner. Okay, so if it's XYZ company, Messrs XYZ company, in that name only the partnership firm should be, the account should be opened, not on an individual partner's name. So when a partner retires, his liabilities to outside parties will cease. Okay, once he retires, he has left the firm. Now you cannot still claim the liabilities to be paid by that particular partner, and all the creditors, okay, who have given loans also to the firm cannot go and claim it from that particular person. So if a partner becomes insolvent, the partnership firm will come to an end. If the firm is not dissolved, new account can be opened after there is solvency, restoration of solvency. Then if the partner does something which is not related to the kind of business that which he has carried out, and then he undergoes loss and all that, he will not be liable for losses or debts that which is incurred. Now at the dissolution of the debts of the firm shall be settled, okay, out of the assets of the firm. So as I said, the liability is unlimited where if the assets of the firm are not sufficient to make good the losses that which is suffered, then definitely personal assets also will be considered of the partners. Then if a check payable to the partner is endorsed by a partner, okay, and it is deposited by him in his personal account, the transaction should be only for checking with the it should be done only after checking with the other partners. All right, then if the partnership exceeds this limit, okay, if it is illegal, it cannot enter into any kind of legal contracts. It all the legal things will be taken into consideration, and it cannot enter into any contract or sue in its own name. Now if a partner joins or leaves a partnership firm, old partnership firm will come to an end and a new one will come in its place. If the documents are signed by the partners individually as well as jointly, okay, the creditors of the of that particular firm can recover their debts simultaneously. Alright, so now let's see the precautions that has to be taken by the firm. So all the instructions about the operation of the account must be signed by all the partners. Any standing instructions given, it has to be signed by all the partners. The specimen signature should be taken of all the partners, and advancing of loans should be done taking into consideration the consent of all the partners. Okay, so in this video I have discussed three different types of customers. So one was your minor, another one was your joint account holders, and now the partnership firms. So I'll make another video for you to continue on this topic, different types of customers. If you all have any doubts, please do get back for clarification. Thank you.